Good evening and welcome to Training Tuesday. I am Bill Brown. I am the Director of Innovative Evangelism for the Baltimore-Washington Conference. And tonight I am joined by William Westbrook, who is the Director of Administrative Services and the Treasurer for the Peninsula Delaware Conference. And it is a joy to welcome our siblings from the Baltimore-Washington Conference and the Peninsula Delaware Conference to tonight's Training Tuesday webinar, which will cover the role of trustees and the important ministry of administration that they take care of. We're going to open with a word of prayer, then I'll go through some housekeeping notes, and we'll then turn it over to our presenter for the evening. So if everyone would join me in a word of prayer, please. Let us pray. Holy and gracious God, we give you thanks for gathering us together from the variety of places in which we find ourselves. As we unite in this space, we give you thanks that your Spirit is present no matter where we are, and your Spirit is present as we gather tonight. I give you thanks for those who have answered the call to undertake this ministry of administration and stewardship and their role as a member of the Board of Trustees for their local church. I just pray that your Spirit would be with us tonight to give us insight, wisdom, and understanding, to open our minds to learn new things so that we can be equipped to do your work in the name of Jesus. Amen.
Amen.
So as we gather tonight, if you do have questions, someone said too much echo, you might have to check your own settings. Some echo things we can control, and some echo issues are on the user's end, so please check your volume settings. If you do have a question, please use the Q&A feature throughout William's presentation tonight. He will pause to answer questions. I do like to remind people that tonight's session is being recorded, and we will make the recording available, and the PowerPoint slides will also be available. Probably not until next week, since many of us will be partaking in the Thanksgiving holiday, and some of us will not be back into the office. And so it does take some time to get those videos ready and posted to YouTube. So please don't worry, it will be posted and you will have access to it. So without further ado, William, Bill, we're Bill squared tonight. So welcome.
Yep.
Thank you for presenting tonight, and I will let you take it away.
All right, everybody hear that or see that? Well, fasten your seatbelts because you're going to take a wild ride through the roles of the Board of Trustees. That is, if my slide works properly. There we go. So what is a trustee? It's a person who holds property and other assets for the benefit of another, known as the beneficiary. And the trustee has a fiduciary duty to act in the best interest of that beneficiary. Now, what does it mean to have fiduciary duty? It's the duty to act for someone else's benefit while subordinating your own personal interests to the other person. And more specifically, it can be defined as a duty of loyalty and a duty of care. And we'll address each of those individually. So a duty of loyalty is a legal duty of the director or officer to act at all times in the best interest of the organization. In this case, it would be your church, instead of in their own interest. The duty of care is a legal duty of the director or officer to act for the organization in the same manner that an ordinary prudent person would act under a similar circumstance in managing his or her own business affairs. And the components of that duty of care are: you have to be reasonably informed, which means you have to attend meetings in order to be able to discuss things before you make final decisions as a Board of Trustee. You have to use reasonable prudence in making your decision, and you also have to use independent judgment. So you can't just vote to go along with the crowd. And why do you need this duty of care? Because if you breach it, you as a body and also as an individual trustee could be shown to have done a willful neglect and could potentially, depending on the decisions that are made by the Board of Trustees, have some personal liability as a result of that decision. So now I'm going to go through some disciplinary paragraphs that cover the Board of Trustees. The first one is paragraph 258.3, and it actually establishes the Board of Trustees, and it's a one-sentence paragraph that says there shall be a Board of Trustees in every local church. Straight and to the point. The next one, which causes a lot of consternation in some corners, is 2501, which introduces the trust clause requirement in all deeds of transfer. And what the trust clause stipulates is that the Board of Trustees for the local church owns the property. It's deeded in the name of the local church, but they hold it in trust for the denomination. So the annual conference acts as the legal body representing the denomination. So therefore, the Board of Trustees hold the property with a beneficiary trust interest by the annual conference. And then 2503 actually addresses the trust clause language that would be in the deeds. And there's two types. One would be for the general worship sanctuary church property, and then other language for parsonage and other like educational wings or fellowship hall sections that are separate buildings. So there will be different language depending on the use of the building itself or the property itself. But that trust clause is the one that has ended up with local churches and annual conferences in court battles over the years on challenging the actual trust clause and its requirements. The Book of Discipline also says that as long as you are operating as a United Methodist Church and receiving appointments and administering your affairs according to the Book of Discipline, whether you have these actual words in your deed is irrelevant, that they will be implied because of your actions. Then we get into 2506, discipline versus local law. And basically it says that local law wins out if there's a conflict between the two. 2510 is a limitation on financial obligations. This doesn't really have anything to do with financial implications for an individual Board of Trustee, but it says that basically no organization can obligate another part of the United Methodist Church, such that the local church can't make a decision that obligates the annual conference. The annual conference can't make a decision that obligates the general church or the local church. There has to be buy-in, and that's why we hold annual conferences, to get votes to hold local churches accountable. And that's why we have a general conference to hold votes that provide guidance for the annual conference. But you can't do it on your own. It has to be done by a conference action. And then 2525 through 2551 are the meat and bones of the Board of Trustees, and it outlines all the responsibilities. So we'll touch base on those. The qualifications, 2525, stipulates that no fewer than 3 nor more than 9 people would make up your Board of Trustees, that's voting members. and it recommends that at least 1/3 be lay women and 1/3 be lay men. They shall be of legal age, and in this case, Maryland and Delaware are the legal age is 18. And 2/3 shall be professing members. This is one area where the Board of Trustees is slightly different than most other committees within your local church. It does allow non-professing members to be voting members on the Board of Trustees. And the reason for this is to allow the board to have some expertise in areas they may not have representation from professing members, like a lawyer or someone in construction, some in land development, things like that. So you can put someone with some expertise that's not a member of your church on the Board of Trustees. And then this question comes up a lot: is the pastor a voting member on the Board of Trustees? They are not by position, but if the local church votes them to be an ordinary member of the board, they would have vote at that point, but not by position. They have to be elected to that board. Speaking of elections, the board is divided into 3 classes with equal numbers in each class, which would mean you would have either 1, 2, or 3 members in each class. They're provided by charge conference election on recommendation by the Committee on Lay Leadership, but you also must allow for nominations from the floor at charge conference. Their term begins with a new calendar year unless it's otherwise stated, and the term is for 3 years or until a successor has been duly elected. And nothing in the discipline in this case prohibits a trustee from self-succession. Unlike a lot of other committees, again, there's usually a 2 quadrennium limit on how long they can serve on a committee, but there is no limit when it comes to the Board of Trustees. Local church conference versus a charge conference. A charge conference can have either a single church or a single point charge, or it could be a multi-point charge. If you're in a situation where you have a multi-point charge, it's not fair for the charge to make decisions about an individual church's property. So therefore, the discipline gives an opportunity for the local church conference to deal with issues that in a single point charge, the charge would deal with directing the Board of Trustees. But when you have multiple points, each church in that multiple point charge would constitute a local church conference with exactly the same membership as a charge conference from each of those individual churches, and they would provide direction in terms of the trustees on property matters. And this next point is one that I can't stress enough, and that is the Board of Trustees is the only body that can legally represent the church in our secular legal system. And many of you have probably, or at least the chairs of trustees, have been involved in communications back and forth around the whole Boy Scout bankruptcy issue. And the chairs of trustees have been involved simply because they are the representative of the full board at this point, and that the board is the only ones that have legal standing with the bankruptcy court. Now, charge conference authority, they give the go-ahead for incorporating your church. One of the things I'll mention here is the difference between being incorporated and then being an association of members. In incorporation, you're limiting the liability to the assets of the corporation. As an association of members, if there were any kind of legal issues taken up by the church, the limitation of liability would not be just the assets of the church, but it could potentially be the assets of every professing member of the local church. And that's primarily why the General Council and our annual conferences recommend that each church be incorporated to limit that liability. They give direction in the area of purchase, sale, mortgage, encumbrance, construction, repair, remodeling, and maintenance of all property. And they also provide for acceptance and rejection of all gifts and conveyances. Now, they don't have to do this on an individual basis. They can designate or delegate that to the Board of Trustees in a single action, but they do have the authority. So if there's any question that comes out of the Board of Trustees on whether to accept or reject a gift, it can be taken to charge conference action for the ultimate outcome. The organization on 2530, the Board of Trustees is to convene at least in the first 30 days of a calendar year to elect new officers. They elect a chairperson, vice chairperson, secretary, and treasurer. And if you're incorporated, depending on your state, they may use the term president and vice president. So for this paragraph, they are interchangeable. So president would be interchangeable with chairperson, and vice president would be interchangeable with vice chairperson. The chairperson and vice chairperson shall not be from the same class. And the chairperson must be a professing member. The secretary and treasurer may be the same person, and officers serve a term of 1 year. So they must be re-elected on an annual basis. For removal and vacancies, a trustee is removed automatically if they withdraw their membership from the United Methodist Church. That would not hold true for those members that were put on the board, either 1, 2, or 3, that are elected for their expertise and not actually a member of the church to begin with. And then the charge conference can also remove a trustee for failure to fulfill their duties. And the church council can fill vacancies between charge conferences. The meetings themselves, meetings are called at the call of the pastor or the chairperson of the trustees. They must meet at least annually, and that would be to hold their elections in the first 30 days. And the majority of members of trustees constitutes a quorum. Now, this is again one that's a little different than most committees. It's the majority of the members, not the majority of members present at the meeting. So if you have 9 trustees, 9 trustee members, you must have 5 in order to hold a quorum and a meeting and actually have actionable items. Your responsibilities as a trustee. Obviously, for the care of all church real and personal property, to provide adequate insurance coverage, and we'll talk more of that a little bit later, to ensure the use of the facilities by outside groups is consistent with the social principles. And you also must maintain the ability to require indemnity clauses for outside groups, and also to make sure they have their own insurance through getting a certificate of insurance. And this holds true if you're using contractors around the church as well. You should always have a certificate of insurance from anyone outside the church that's using your building, and that would name your church and Board of Trustees as an additional insured in case something happens on the premises as a result of that group using the church. Along with the SPRC committee, you do a parsonage inspection annually. and you manage bequests, legacies, and trusts as they become available, and also conduct an annual accessibility audit. From all of that, then the committee has a responsibility to report to the charge conference each year, and that reporting requires a legal description and valuation of each piece of real estate, the name of the grantee of each of the deeds of conveyance for that real estate, an inventory and valuation of all personal property owned by the church, and any amount of income received from income producing property that you may own. Also, amounts received from a building campaign and any expenditures out of the campaign need to be reported. Any outstanding capital debt, a statement of insurance coverages, the name and custodian of legal records and location of those records. And this is one I'll highlight that you need to pay particular attention to, because what I've experienced in years past is the form of the report to charge conference hasn't changed much in the course of 10 or 15 years. What ends up happening is the Board of Trustees will keep the same information on there year after year, not realizing that the person that was the custodian of those records either has moved or has passed on, and no one knows where the records are. So it's critical that you keep this custodian of legal records and location up to date annually. List of all trusts, naming the church as beneficiary, and you provide the results of that accessibility audit on an annual basis. Now, you have relationships to other groups within your church. You have a relationship to the charge conference. We just talked about the report that you need to make. You have a relationship to the church council, reporting in between the charge conference, activities of the Board of Trustees. You also have a relationship with the Staff Parish Relations Committee and a representative from the Board of Trustees will sit on the Committee on Finance so that they have an idea of what kind of financial commitments are necessary for the Board of Trustees to fulfill their duties. And if your church has a business administrator, you're obviously having a dialogue with that person in order to authorize any expenditures associated with the work of the Board of Trustees. All right, at this time, I'll take a few questions if we have any, Bill, about the actual role and disciplinary requirements.
You are covering things very thoroughly. We have one question so far. Now, this could spur other questions. Well, one of our participants asked, is there any problem of delegating some of the financial functions to the Finance Committee? For example, monitoring investments in financial instruments and endowment funds.
I would suggest that since you already have a representative of the Board of Trustees that sits on the Finance Committee, that would be appropriate. But if you're talking about larger sums of monies, I would suggest that you set up an endowment fund and a separate endowment committee and have that authorized by the charge conference, and then they would oversee that. And you could have members of both the trustees and the Finance Committee sit on that endowment committee, and that would probably be the most appropriate because they would provide for their own investment policies just for that endowment.
And I think as you mentioned last week, the importance of being prepared to receive endowments. And so doing some of this work ahead of time before you may have any endowments.
Correct.
We have another question. Is the pastor required to attend each and every trustee meeting? Can the trustees hold meetings without the pastor being present?
That would be a yes on both parts because the pastor does not have a voting position on the board unless they are actually a voting or elected member of the trustees. So it's not required that they attend. Now, if they are an elected member, they should be attending to make sure that they can qualify for that duty of care qualification of being well informed. But other than that, it's not required for the pastor to be at the trustees meeting.
And another question that's come through is, can a church have a junior trustee, someone who is under the age of 18?
They can have persons that serve what I would call ex officio, but they would not have vote. They could have voice, but they would not have vote. Just keep in mind, this question crops up, I think, on every committee. You know, can we have extra people other than what's designated by the Book of Discipline? You have to keep in mind that all meetings, except for the SPRC, when they're talking about personnel issues, are open to anyone to the local church. So we have an open policy. So anybody can attend.
All right, those are all the questions that have come through, Bill.
Okay.
So I would remind people, if you do have a question, feel free to use the Q&A feature on your Zoom platform, and we'll have another opportunity as we move through the presentation. So thank you.
All right. Let's move on to some insurance issues. Some types of insurance that are required are property, fire, and theft, general liability, sexual misconduct, directors and officers liability, employment practices, workers' compensation, and auto insurance. So I know your head's spinning. Lots of insurance. But the General Counsel on Finance and Administration has a insurance company that they work through, and they provide a minimum coverage policy for local churches that they're supposed to compare each year their insurance coverages against this minimum to make sure that you're fully covered. And according to their policy, your property insurance is covering your buildings, pipe organs, contents. If you have stained glass windows, that would be covered. And it should be insured for a replacement value with special risk coverage. All church buildings should have an updated replacement cost valuation at least every 5 years. And the replacement cost valuation must be updated within 180 days if you add additional square footage to your property. In some circumstances, your insurance carrier may not offer you the replacement cost and put it on a cash basis only. And that typically is because you need some major repairs. So if the church building, it can be insured on a cash basis where the replacement cost valuation is not an option, and the church should understand that is being insured on an actual cash value basis, and its best efforts to complete whatever necessary upgrades or renovations required to qualify for replacement cost valuation coverage should take place. And basically what this is saying is, if your building were to catch on fire, you would not get full replacement cost to rebuild that church. It would be based on some kind of a depreciated value of the property. So it behooves you to have your coverage on a replacement cost. Otherwise, it may be in a position that you will not actually be able to rebuild your church. And you just need to understand that. Some other limits of liability, commercial general liability, $1 million per occurrence with an aggregate of $3 million. pastoral counseling liability, an occurrence of $1 million, an aggregate of $3 million. Hired and non-owned auto liability, same with an occurrence of 1,000, an aggregate of, or $1 million, and an aggregate of $3 million. Now, one of the things I want to point out, like in pastoral counseling liabilities and some of the other liability insurances we'll talk about a little bit later, like sexual misconduct, the policies can be written in two different ways, and you have to be sure you understand how your policy is written. It can be in an occurrence method, or it can be when the claim's made. And the difference is, in an occurrence, the insurance company will cover it if the act occurs while that policy is in place. And it's different from claims made in that it's covered under the insurance when the actual claim is made. So we're dealing with that right now with the Boy Scouts in the sexual misconduct arena, that if your policy was such that it was based on a occurrence, which most of them would be, we're looking at coverages that would have taken place anywhere from 10 to 20 to 30 years ago. And it would be up to you to determine what insurance policy was in place at the time the misconduct occurred. Had those policies been on a claims made, it would have been covered by the 2020 insurance policy, because that's when all the claims in the Boy Scouts bankruptcy actually were placed. So keep in mind when you're looking at your policy, determine whether it's a claims made or occurrence method. The employee benefits liability is an occurrence of $1 million and an aggregate of $1 million. This only really pertains to churches that have employees that they provide benefits to, either a health insurance, life insurance, or a pension program. And this coverage provides for if you make a clerical error or something and you don't properly deposit maybe a pension contribution to an individual's account, and later it's discovered that that they were denied, they could take the church to court and ask that their benefit be brought back up to what it would have been if the error had not occurred. And that's what this liability insurance helps to alleviate. Crime, employee dishonesty, minimum is $25,000, but it really is going to depend on the activity and size of your church, as well as medical payments. Now, the sexual misconduct liability comes in two layers. For a church membership of 500 or more, the minimum coverage should be $1 million for occurrence and $2 million aggregate. And for a church membership under 500 would be an occurrence of $250,000 and aggregate of $500,000. And we have directors and officers liability for $1 million. Employment practices liability, option number 1, is $1 million. And that's required again for churches with 500 or more members. And the employment practices liability gets farther than just the benefits, in that how you hire somebody, how they're treated within the local church, thus the sexual harassment needs to be included, and a lot of times they'll try and exclude it from this policy, so make sure it's included. But it's how you hire and fire people that this coverage would be in place for. And if you're under 500,000, the coverage would be 250,000 minimum. And that's if you don't have a preschool, a school, or a camp associated with your church. umbrella and excess liability. This is over and above the other coverages we just talked about. It's suggested for churches and required for those with a membership of 500 or more. And if you're going to have it, it needs to be in excess of all these coverages: the commercial general liability, pastoral counseling, employee benefits, owned auto, hired and non-owned auto, workers' comp. And this is in place to cover, we had the occurrence and then you had aggregates. So if you have a bad year and you go above those aggregates, then the umbrella gives you another layer of insurance above that. Then we have workers' comp, which is required by each state. And I would advise you to look at, well, the insurance carrier should know the requirements within your state. But for the minimums, they recommend $1 million for each accident, $1 million for any disease, and $1 million for each employee. Commercial auto liability, if you own automobiles only, and the limit of liability there is $1 million. And if your church is a fairly large church and has a boiler system, you're looking at an inland marine type policy to cover damages that might occur from burst pipes or things like that within the church. So one of the ways that you can try and affect your premiums that you're paying on these insurances is through risk management. And you want to be looking out for fire hazards like damaged wires or overloaded outlets and surge protectors, things like that. And the insurance, a lot of times the insurance agents or insurance companies will bring out adjusters and do periodic inspections of your buildings. And they'll give you hints on where they suspect some fire hazards and slips, trips, and falls might take place, and give you a list of things to help mitigate the liability. But for slips, trips, and falls, you're going to be looking for raised sidewalks. You might find potholes in the yard somewhere, or loose carpeting in one of the classrooms, and stair treads are a big one. They need to be kind of roughed up so that individuals won't slip going up and down the steps. Then nursery and daycare centers are a particular issue. You need to make sure you have a licensed director and your staff is well trained, and that they're following the sanctuary policies, and make sure that they are actually being followed. And then you're going to look for things that small hazards or whatever in the nurseries to prevent any kind of choking hazards. And sexual abuse, again, you have safe sanctuaries policies in place, but you have to make sure that they're being followed to the letter of the law. Now I'm going to switch off of insurance and get into a couple of other areas that have cropped up in recent years, and that's parsonages themselves. So in your parsonage, as we mentioned earlier, there's to be an annual inspection with the Staff Parish Relations Committee. And the reason for that is to make sure that you're maintaining the property adequately, and to address any issues immediately so that we don't defer maintenance and end up causing problems for the pastor. You want to again look at accessibility issues, especially if you have someone that has mobility issues living in the parsonage. And then areas that have come up recently would be, can I rent the parsonage? And what about selling the parsonage? So if you're thinking about renting a parsonage, first thing you have to understand that it is going to require a written lease agreement. And if you rent the parsonage, that means it's no longer available for your pastor, which then means that you would provide a housing allowance to your pastor instead. So you need to determine what that housing allowance would be. And in a rental situation, you still have maintenance and insurance required on that property. And since it's no longer being used as a parsonage, you'll have local property taxes to pay on that property as well. So those are some things to think about when addressing whether you want to rent your parsonage or not. Then if you're thinking about selling the parsonage, a lot of times this comes into play when you have you get a lot of your major components of the home reaching their end of useful life, like the heating and air conditioning systems, the roof, maybe the windows are in need of bad repair, or you're tired of painting it every 5 years. So you're looking at the potential of selling that parsonage. Again, that would require charge conference action. And you would also then have to provide a housing allowance to your pastor. So you need to figure out what that would be. You have to understand that the proceeds for any sale from a parsonage would be restricted to either capital improvements or for assisting in providing a housing allowance for your pastor. But a big question would be, do you require your pastor to live in the local community? Because if you're not providing the parsonage there, there's nothing that says the pastor has to buy or rent housing within that community. And it could be very well that there's no housing available, depending on the particular area you're in. In some of the rural areas, there may not be housing available at all when the pastor happens to move and get reappointed to your congregation. So then it would be your obligation to come up with some alternative housing or provide that housing allowance and know that your pastor is not going to be in the vicinity of your church. So those are some important questions to ask yourself if you're even thinking about selling your parsonage. Then I'll move into cemeteries. Another problem that's brewing in the background. And the question is, do you incorporate your cemetery separately? Some things to think about when answering that question is, can the cemetery and church property be separated and have two separate deeds? I know the Peninsula Delaware Annual Conference has recommended that cemeteries do in fact get separately incorporated, and that's for two main reasons. One is the liability issue. We've had instances here where family members of persons interred in the cemetery have gone to the state and complained and the state has required major maintenance within the cemeteries. And if it's not separately incorporated and part of the local church, then the local church has to provide for those maintenance items. If it's separately incorporated, the cemetery itself would only be liable for the assets that they currently maintain as far as perpetual care funds in maintaining that property. The church would not have to be made liable for any repairs on the actual cemetery itself. So that's one reason to incorporate a cemetery separately. And the second is, if the church were to cease to operate as a church in the future, you still have the capacity to operate the cemetery as an ongoing organization since it's separately incorporated. So those are the two main reasons that we recommend a cemetery be separately incorporated. One thing that I find over time is that records are not accurately kept from a historical basis. I know some of the cemeteries here on the peninsula date back to late 1790s to early 1800s. So a lot of those records I know are not not kept well. And it's only been a fairly recent phenomenon that you'd have perpetual care funds. When most of our cemeteries were instituted, it was almost like a rite of passage to members of the church that they would be buried in the vicinity of the church building. And there was no mechanisms by which the future care of that property would take place. So if your cemetery is currently without a lot of perpetual care funds, a recommendation would be to look at persons that are interred in the cemetery and try and locate family members or relatives and put out the call for assistance in developing or adding to the perpetual care funds for the future of that cemetery. And lastly, it's recommended that you would register those cemeteries with your state. One of the advantages of doing that is the states have what they call distressed cemetery funds that you can request. I know in the state of Delaware, you can get up to $10,000 grant if you can show that your cemetery is in poor state of repair and you are interested in bringing it back up to a decent standard for your church and for the persons interred in that church. So again, Bill, I think I'm gonna open it up. I see there's like 7 questions there.
I'm responding to one. So first of all, I do want to mention that we have in the audience tonight, John Strawbridge, who is the chairperson of the Baltimore-Washington Conference Board of Trustees. And he just wants me to remind people that the Baltimore-Washington Conference Trustees also recommend separate incorporation of cemeteries. So we're in alignment. He also wants me to mention that Maryland has different laws for nonprofit versus for-profit cemeteries. So people may want to Google Cemetery Oversight Board for the state of Maryland if they have specific that are different, that would be different than in Delaware.
Mm-hmm.
So let's go through some of these questions. I'm going to start with one that pertains to this section. And then we have a couple of questions from previous sections. So first question is, does the trustees chair need to have the church vote to add additional insurance to cover things that were not previously covered in the old policy? So what process should the trustees chair use if they have to add to the insurance policy?
Well, the trustees are responsible for that policy. So what they would need to do is communicate with the finance committee on and determine what the additional cost would be for adding that coverage on. But that's a sole responsibility of the Board of Trustees.
All right. So what I do hear you saying is the chairperson should consult with the entire Board of Trustees so that they're not necessarily having to make that decision on their own. Is that correct?
Well, that would be a decision of the board itself, not by the chairperson.
Okay, now around parsonages, 2 similar questions. Do you have to pay taxes on the rent received for renting out the parsonage?
That would be a no. The IRS looks at this as a situation where you have excess space that you're renting, but you're holding that for potentially a nonprofit use in the future. It's just that you're not using it for that purpose right now. And it would only be a situation if you're just doing the parsonage itself. Now, if you own 4 or 5 rental properties, that would be a different situation because it's not just a parsonage. But the fact that this is a parsonage and considered excess space that will at some point in the future be used for the nonprofit purpose, the IRS does not require that to be recorded as a taxable income.
Okay, thank you. Oh, thank you, Bill. I'm gonna just remind our participants tonight to please use the Q&A feature to ask your questions. Please don't use the chat to ask questions. We're trying not to keep track of too many different areas. So please use the Q&A feature if you have questions. Now, a couple of other things that have come up. You talked about the relationship between the Board of Trustees and the Church Council. Does the chairperson or a representative from trustees serve on the Church Council?
They report to the Church Council, yes.
So they could be on the Church Council, or they may just come in for a report, or is that dependent upon the local church?
Depends on the local church.
Okay, and you mentioned the Endowment Committee. Is this a separate committee, or is it a subcommittee of either trustees or finance?
Typically, the Endowment Committee is a subcommittee of the Board of Trustees, or a separate committee reportable to the Board of Trustees.
Okay. And let's get through some. Another rent question. Is it restricted? I'm not quite sure. I'm going to just ask it the way they wrote it. Is the rent restricted for use by the church?
I would say yes. I don't
So
know who else would use it.
I'm going to look at it two ways. So yes, the rent has to be used by the church. Is there restrictions on how the church uses the rent?
No, there is no restriction. Unlike when you sell it and it has to be used for capital improvements, the rental income can be used for anything.
Okay, and we had a final question about membership on committees. And the participant asks, if an individual is a member of a committee on an ex officio basis, that is based on being in another position that puts the individual on the committee, don't they automatically have a vote? Now, the exception they cite is if it's a paid employee. But if somebody, are there instances where people are on the trustees by virtue of their office someplace else, and do they get a vote if that's the case?
No, they would not. They would not be there by position. The discipline is clear that you only have up to 9 members on your board, and they are elected by the charge conference on recommendation by the Committee on Lay Leadership. So there is no ex officio possibilities on the Board of Trustees.
So anyone can attend, but voting members must be elected by the church or charge conference.
That's correct.
Okay, now you can settle a dispute then for one church. If the finance committee is not in agreement with raising the insurance coverage, can the trustee still move forward?
If you have a battle between the two committees, my recommendation would be to have the Board of Trustees put that before a special charge conference and plead their case as to why it's needed.
Okay, so you can always go to the charge called charge conference.
That would be correct. The charge conference is the ultimate authority.
And how often should the status of endowments and annuities be reported to the trustees, or how and updates on how they're being used? How often should that happen?
I would say it probably depends a lot on the size of the endowments, but I would think that an endowment report at a minimum should be given at least once a year for any smaller endowments. But I would think that every time the trustees meets, that a report out of the endowment fund committee would be appropriate.
Okay. And last question is, should replacement cost valuation be done for renovations that do not increase square footage?
Well, they wouldn't necessarily have to at that immediate time, but it would be factored in with their next valuation within that 5-year period.
Okay.
And I would make a caveat that it would depend on the nature of the renovations and what the added cost would be to that. So if it's a major internal renovation, I would suggest that you probably get it revalued, even though it doesn't have a square footage, because of just the sheer value of the renovation itself adding to the cost.
Okay. And let's see, a few more questions come in. If a parsonage is sold, can some of the funds go back to the church treasury for the amount of money that was used for previous repairs?
It would depend on what you're referring to as a repair. If it were a capital repair, possibly. But if it were just a regular routine maintenance kind of item, no, would not cover that.
Okay. And back to, I'm just popcorning around, back to endowments. We're keeping you on your toes today, Bill. Back to endowments. Can the trustees, through a resolution, hand over endowment authority to another committee other than the endowment committee?
Not without charge conference action. So in a sense, they would be making a second endowment committee. And that would have to happen through charge conference action.
So it's the charge conference that sets up the endowment committee.
That's correct. But they're
Okay.
reportable then to the trustees.
Got it. Now, how important should it be for adequate capacity signage in the building before renting out parts of your building?
That I don't know whether the capacity signage is more important than setting that within the lease agreement itself, setting the maximum amount of people that you are allowed. I think the written document is more important than having it as a sign listed on the building.
Okay. We're going to popcorn back to, we're still having disputes between finance and trustees. Surprise. You mentioned going to the charge conference.
Uh-huh.
Is there any role that the church council or administrative board would have in deciding the issue?
Yeah, that could be a first start to try the administrative board or council and beg the case there. But ultimately, the deciding authority would be charge conference. But if you worked it in through a budget kind of discussion, the budget can be modified by church council in between charge conference sessions. So that is a possibility.
Okay. And I don't want to say last but not least, because every time I say that, Bill, someone pops in with a question. So here's one. What should be done if a member of the community wants to leave land to the church?
Okay, that leads us into that endowment and gift acceptance policy that should be in place. And it would address what happens when somebody gives you land. The most important thing about a gift of land is before you take it, you need to make sure that there's a minimum environmental study done on that particular piece of property, unless you're very familiar with it and know that nothing has transpired on that property that would cause any kind of hazardous waste issues. But if you have no familiarity at all with land, you definitely want to have an environmental study done on it. And I can give you a caveat on that. We sold a church in Wilmington about 10 years ago, and we had an environmental study done. It was a church and a parsonage, and we discovered that most of the city of Wilmington is constructed on backfill. And a lot of that backfill happens to be the spent coal, the coke from the trains that ran through the town. And now that is leaching into the ground. So we found out that the parsonage was no longer able to be used as or inhabited as a residence. It could be used as an office, but it could not be used as a residence, just simply because of that environmental issue. So you definitely want to take that into consideration before accepting any land at all. And if it comes, if it comes clean, then you're good. If you take the gift and then you discover that there's hazardous waste on it, the church now has the obligation to mitigate that hazardous waste risk.
Bill, believe it or not, people will try to donate valueless, damaged land and buildings and other items to churches. So do your due diligence is what I hear you say.
Correct. Yep.
As I said, just as soon as I say last but not least, another question, and then we're going to move on and we'll have another set for questions. But who is in charge of undesignated funds from a bequest? Is it trustees or is it finance?
Generally, what we try and say there is to have either the Board of Trustees set up like a wish list of things that they would want if they had the money for it. But typically, again, in this gift acceptance policy and an endowment arena, you're going to set up a small, what they call memorial committee for undesignated gifts, and the Board of Trustees would provide this wish list to the memorial committee, and then they would work with survivors to determine how best to utilize that undesignated gift.
Excellent. Before anything else pops in, I'm going to have you continue.
Well, I think I'm just about done with my presentation, Bill.
Okay.
But I did want to add one extra thing too that I didn't
Excellent.
mention when we got to the incorporation of the local church. The Board of Trustees are elected by charge conference, but because the Board of Trustees also is representative to the outside legal, if you're incorporated, then the Board of Trustees also must be voted in by action of the church. So in addition to the charge conference, the new members coming in have to be voted on at a regular session of the church, which typically happens in most cases after a worship service or something like that, in which they've given notice at least 10 days in advance of the vote in two separate ways, either in a newsletter posted on the door or announced from the pulpit or put in the bulletin. So any two of those methods 10 days before the vote, and to make it satisfied for state regulations, they would have to be voted by the membership of the church present at that meeting.
Now, I'm going to throw a wrench with my own question. Would that be covered if, I know in the Baltimore-Washington conference, we typically have church conferences, not charge conferences. Would that if it's a church conference, would that settle it being a vote by the church since all members of the church are eligible to attend and vote?
Yes, that would be sufficient.
Okay.
As long as all the professing members are invited. Yes.
And all of the other requirements are met, and somebody is asking that question, and yes, a church conference would suffice. Somebody's asking, you are assigned on a committee to help draft rental leases for the church. Should you have a fire marshal or someone from the fire department help in establishing what your capacity boundaries are for rental agreements?
If you're unsure of that, I would say that would be an excellent way to make sure that you're within the bounds of the fire marshal. Yes.
All righty. And this next question I might be able to answer. Somebody's asking about how do trustees function on a unified board, or would that be a separate training? It is a separate training for our question asker. On December 14th, we are offering a training Tuesday on this the single accountable board or the one board model or the unified board. It goes by a lot of names, and they will cover how different aspects of different church roles like SPRC, finance, and trustees are handled under that single board model. So that's going to be on December 14th. And both annual conferences have sections on their websites labeled Training Tuesday. And so depending on which conference you are a member of, you go to your conference website, click on Training Tuesday, and there's a place to register for all of our upcoming Training Tuesdays that are being offered. So December 14th, we'll have more information on that for our question asker.
So one other thing, Bill, that I'll probably add too, in connection with the use of the building, and that is that the Board of Trustees, while they have authority to make sure that rentals or people using the building stay within the scope of the social principles, they do not have carte blanche authority to deny use of the church, especially if it's something that the church, another committee or organization within the church wants to use the building for. The Board of Trustees can't simply override that because they believe they have authority over all use of the building.
That is very good to know. Very good to know. I'm going to give people a minute if they have any other questions while I announce next week's Training Tuesday. If you'd like to participate next week on November 30th, we are having a Training Tuesday entitled New Ways to Engage People for Ministry in COVID. And next week's webinar is going to explore how COVID has changed the way people are engaging in church in general, and how to re-engage them so they're willing to do the critical work of ministry. So if you are like most of our churches, if you're struggling because people have disengaged due to COVID and are looking for ways to re-engage people, next week's Training Tuesday is for you. Or if you want to let people on your lay leadership and nominations committee know about this, is a good webinar for members of the nominations lay leadership development committee to participate in. And once again, you can go to either of your conference websites, either bwcumc.org or penn-del.org. Both have Training Tuesday areas and separate registration links. So it's very important if you're with the Peninsula Delaware Conference to register through your conference website. If you're with the Baltimore-Washington Conference, register through your conference website. So there's less confusion about accounts and profiles. You should already have one with your annual conference. So that's a webinar you don't want to miss. And then on December 7th, two of our district superintendents, Reverend Joe Archie from the Peninsula Delaware Conference and Reverend Sarah Schlickert from the Baltimore-Washington Conference, will lead us through a staff parish relations committee webinar. And then on December 14th, Reverend John Z. Cogman and Reverend Donna Claycomb-Sokol will lead us through a webinar on the one board accountable structure model. So please register for those. No other questions have come in, so we're going to cut off the questions and we're going to conclude by saying, Bill, thank you so much for taking the time 2 weeks in a row now as you catch up with Paul as our guest presenters, 2 weeks in a row now to provide us with some important information. A lot of people don't always keep up on the important ministry that these administrative committees do. And so I appreciate you taking the time and guiding us through the work of trustees, particularly during a holiday week. So I pray that you have a blessed Thanksgiving. And to everyone who has been participating with us tonight, thank you so much for taking your time out on a Tuesday night right before a holiday to join us. And the slides and the video will be available sometime next week on each of the conference websites. So once again, thank you. Have a good night, a happy Thanksgiving, and God bless you all.
Good night.